Charles is here today to talk with us. He's going to be um, discussing what we call a deal deep dives section, and he's going to be talking about some of the new rules and regulations and laws. Is that correct?
Yeah, I'm going to try and untangle the residential eviction moratoriums and give a couple of strategies for real estate agents.
Awesome. So before you dive into it, do you want to introduce yourself a little bit for someone that maybe hasn't seen you here before?
Sure, yeah, I'm an attorney. I specialize primarily in real property. Most of my work is with residential and commercial landlords. I generally don't represent tenants. I also do some transactional work in terms of helping folks, whether it's boundary disputes, sale by owner, or creating easements and so forth. Generally, my practice is uh, all aspects of real property, but the majority of it has to do with residential and commercial landlords.
And he is good at what he does, I promise. So, Charles, I'll let you take it away. Again, if anyone has any questions, please throw them in the Q&A or the chat box, and we'll get to them when we can. All right, Charles, it's yours.
Okay, so all of you know, I'm sure, that in 2020, the legislature and the governor at various points decided that tenant rent was not due and didn't have to be paid. And so a landlord could not terminate a tenant for non-payment or without cause, like when your tenancy is ending. The legislature met in an emergency session at the end of December and passed a bill called House Bill 4401. And it did a couple of things. Number one, rent became due on January 1st. A landlord's required to send a tenant a notice of their rights and a declaration to sign. If the tenant signs and returns that declaration, then they cannot be terminated for non-payment of rent until July. At that point, according to that law, all the back due rent from April of last year becomes due. I will note that the legislature is meeting right now, and that one particular provision, they are likely to give the tenants another 6 months to pay the rent that was not paid between April of last year and whenever the moratorium ends for them. One of the other pertinent parts is that the legislature said that normally in Oregon, during the first year, you can give your tenant a non-renewal notice. The legislature said you can't do that. You can't do that until after June 30th. In essence, they said the first year of the tenancy, if it ended between April of last year and August 31st of this year, it's been suspended. So you can't give that non-renewal notice until after June 30th. The other piece that's pertinent to real estate agents, the legislature said that you can do a 90-day notice of termination where where you have a contract of sale and the buyer wants to move in and use it as a primary residence, where the owner wants to move in themselves or an immediate family member, where there are substantial renovations during which the place will not be habitable, or where the landlord is demolishing it or taking it out of the rental supply. That 90-day notice is available now. So what's going to happen next is the great question. The moratorium is supposed to end on March 31st unless the tenant signs and returns that declaration of financial hardship to the landlord. It appears, and this could all change between now and tomorrow. Tomorrow is the last day that bills need to be assigned to committee for further debate. So tomorrow we should know what's being debated and what is dead for the session. It appears that they are not going to extend the moratorium, but it does appear, as I stated, that they're going to extend the period of time for tenants to pay back the rent that was not paid last year. The other little tweak they're going to make is they're going to say where tenants have their buddies bunking up with them, the landlord cannot necessarily terminate them for unauthorized occupants. If the unauthorized occupants want to apply, the landlord would be required to screen them and see if they qualify for tenancy and then let them stay. And that again is a response to the pandemic. So there are a lot of twists and turns to this, but I've tried in a few minutes to cover the highlights. Does anyone have any questions about the moratorium or anything I did not cover?
Yeah, Charles. So for the 90-day notices, if the property, that you touched on, whether it's uninhabitable, family member moving in, that sort of thing. For some reason, I thought that during the moratorium, and I don't know if it's still going on, that there was only 2 that were allowed. Whether if you were selling the property and the buyers wanted to be attendant for a primary residence, or if you or your family member was moving in. So now all 4 of them are good.
Now all 4 of them are available. You are, give me 1 second here. Sorry. Sorry about that. I have some barking dogs. You're correct. Last year through from April through September, none of them were available. And then because of the lobbying, primarily by real estate lobbyists as well as landlord lobbyists, the contract of sale exception went into place in September of last year. And again, that's where a buyer intends to occupy the property as a primary residence. Once that contract of sale is signed, but before closing, the landlord can send that 90-day notice. Then in December of last year, the exception for moving in yourself or an immediate family member came into play. And then in January, the other 2, demo or substantial renovation, became allowed. But these things all only came into play because of pretty aggressive lobbying by landlords and realtors. Fundamentally, there are 2 forces at work. There's both the public health aspect, that they don't want people to be evicted during the pandemic, but there are also tenants advocates who are taking advantage of the pandemic, and fundamentally they simply don't want tenants to have to pay rent. I mean, I know that sounds pretty harsh, but that is fundamentally the case. They made it very clear in the law that rent simply was not due. And I will note that that is an unconstitutional infringement on the right to contract, both federally and on the state level. But the federal courts have been slow walking those hearings. And odds are they're not going to do anything with them until the moratorium ends in June. And then they're going to say, oh, it's moot. We don't have to address the question of whether or not the governor has power to infringe upon contracts, because the Constitution clearly says they do not. So it's just one of those things that the pandemic has trumped basic right to contract right now. And if you are kind of a dork like me and you follow litigation around the country, in both Texas and Ohio, federal courts have said exactly that the private right to contract supersedes the pandemic. Basically, that had it been only for 3 months, like it was supposed to be in the beginning, then they would have let it stand. But at this point, it's gone on for a year, and in Oregon, they would like to extend it as long as possible, which makes it an unconstitutional infringement on the right to contract. So, long-winded answer, all 4 of those rights are available to landlords and their agents at this time.
Awesome. That you hit it on the head and answered everything I was asking about. We do have 1 question from Mona. Taylor, you got it?
Yeah. For multifamily, do buyers need to occupy 1 unit for that owner-occupied situation to occur? I believe that's the question, Mona. So, yeah.
It's a two-part answer. Number one, if there is no other available unit, then the buyer can pick one, ultimately. However, there is a part of the regular law that says that where it's a duplex, the owner can give a notice to both units. That is still unavailable until June 30th. But the concise answer to the question is, if there is no other available unit in the building, then you can serve that notice on that unit. You would then probably need to rebut a presumption that you're picking on that renter. You are discriminating or you are retaliating. So you would need to explain why that was the unit that you chose to move into.
What if they chose the unit that has lower rent? Would that be considered picking on them? If the two units are rented for the same amount?
If they're rented for the same amount, yes, they would be open to that line of attack.
But if they were different, so let's
If
say
they were
one's at
different,
1,500 and one's at 1,000, and they chose the 1,000 one because they know they're going to get more in revenue from the 1,500.
that would be correct, but I would want them to phrase it that the lower unit rented for less, and that was what they could afford in terms of their carrying costs. I would want them to avoid any specific line of argument against any particular tenant.
Okay.
That's good. If anyone has any other questions for Charles as we move forward, definitely throw them in the Q&A.